we are kicking off a brand new segment on Property It's Hot. All your property-related troubles, be it any buy or sell dispute or tax dilemmas, we'll serve you up with the smartest expert advice you can find to get you out of the problem. Today, we're focusing on the most common problem in property buying, possession delays. Listen in closely. Thanks very much for joining us on Smart Advice, the space where you get all your key concerns resolved when it comes to buying or selling property. Every week, we bring you unique questions from the viewers, typical of problems that you may encounter when you actually go out to buy, sell property. Legal, finance, tax, we'll cover all of it in this special series. Today's focus, something that so many buyers are battling across the country, delay in possession. What happens when your developer isn't giving you your flat in time and you have a loan to take care of, EMIs to take care of? Those are critical issues, so we'll start with that. Let me introduce my guest today to you, Samarjit Singh, MD India Home. Samar, thanks very much for being here. And of course, we'll also be joined from our Mumbai studio, Vinay Singh, property expert. Vinay, hi, thanks for making the time to take our questions. Okay, so let's go across to our first caller. We've got Sumesh Manchanda on the phone line. That's the question of the week. Sumesh, go ahead, spell out what happened.
Hi, I booked a flat in Akruti Gardenia by Akruti Developers in Meera Road on March 2010. I was promised by the developer to give me the possession by March 2012. And I took an advanced disbursement facility by the developer in which the developer was about to share 50% of the amount on a pre-EMI interest. And now they have increased their possession till December 2030. So I just wanted to know, should I stick on with this property or should I just release it, and how should I release it?
All right, Samar, so very typical problem, delay in possession, and of course the guy is also straddled with financing costs which he hadn't anticipated. He had thought that by the time his subvention scheme or pre-EMI phase is over, he would get his apartment or would be very close to getting his apartment. So what happens? It's a double whammy.
So Manisha, basically what happens is in many cases these days, execution and development and final handover is getting delayed. So this problem is coming up in many formats. Here there might be a subvention scheme, but in other areas there are customers living on rent. So our suggestion is that right at the time of taking or buying a project, he should have been more careful. There is no way a project of this nature could actually have been done in 2 years' time. So our suggestion would be that since prices have gone up dramatically, it has been a good investment. I think the financial stress he's currently facing, he should deal with for now and make sure that he continues to pay for the extended period until he's able to get possession. As you know, the environment is changing now, so there are many more legal options available to customers, and there is no concern around pursuing recovery of his extra payments after he has physically got possession. And I don't just mean this specifically for this project, but overall I think if you actually look at what it needs to be done to secure yourself so that the project can be handed over successfully, you are complying with the payment schedule so that the developer does not get any opportunity to cancel your allotment, which will be a great value loss to you. If that can be done, and then after that there's a whole host of avenues open to you to recover the extra money that you have paid because of the delay from the developer side and no fault of yours.
Okay, so whenever you agree that's a smart advice, property prices have gone up all over the country, so it isn't always in the favor of a buyer if he is encountered with a delay in possession to actually get out of the project. You take the possession, you go along with the developer, and then later on you fight for your rights. Or is there another solution that we can give?
Well, Manisha, actually there's very little choice that any buyer has in this scenario. The only choice he has is to stick on, make all the payments, take possession, and then decide whether he wants to pursue a legal battle or not, which usually the case is that the buyers do not pursue any legal battle. Now here, we've said it so many times on this very show itself that at the time of signing up, you must be very careful, go through the agreement, consult somebody, and have that agreement made in a watertight manner. Because later on there are so many escape clauses. I mean, if you look at the force majeure clause that most builders put in the agreement, virtually anything is force majeure. No labor available, he is not responsible. No cement available, no sand available, in fact no steel available. All these are according to the builder force majeure. So A is that, I think the entire term force majeure as far as it relates to our construction contracts needs to be redefined. Force majeure could be maybe an act of nature or a change in law or things like that, but shortage of things, materials and labor should not form part of force majeure in my opinion, because this is what builders used to typically wriggle out of their commitments. So this is something that needs to be addressed. The other thing is, we may have any kind of regulator that we like, but always in a contract there are going to be areas which are subject to what the parties agree upon, and this is always going to create a problem. You may have the best law, you may have the best regulator, but where it is subject to negotiation, it is up to the consumer and the flat buyer to negotiate that particular area. So this is what I feel should be done going ahead.
All right, so I also want to understand that once when he does get possession, will he have a legal recourse left after that?
See what happens.
Or do you think that most
Manisha,
buyers just
yes.
let it be then?
What he should do in my opinion is that he must put it on record that there is a delay and I would like you to compensate me for that. Having put that on record, then he can go ahead and pay whatever monies are he is being asked to pay under protest. At a later date, even if the builder does get him to sign a document saying that, listen, I have no claims, etc. at the time of taking possession, he can always argue that I had no option but to sign that document because I needed the possession. And I've already put on record the fact that I need to be compensated for the loss that has taken place. Every judge or authority is well aware of what power a builder has and how much stress there is on a flat buyer if he is dispossessed of his house. So I don't think that will be a serious impediment, provided he puts something on record right away.
All right, so put something on record right away, but pay under protest, so that later if you actually feel that the financial duress has been very big, you can actually file a legal case. The force majeure clause that he was talking about right now in a buyer-seller agreement, even things like not having labor or not getting steel and cement and sand in time, which really a buyer is not responsible for, could be an excuse for the builder to delay. Is that likely to change in the coming days? I mean, how do I as a buyer get that changed in my favor?
So Manisha, that has already changed to some extent because of the activism now. The courts, the Competition Commission of India, they've all got involved. There's a few recent very strong judgments against developers, and by and large the judiciary has understood that this is a very one-sided unfair relationship. So not only in future now when the real estate regulation bill comes, these items will get standardized, but more importantly the judicial activism in this area has increased. So customers' chances of getting justice or getting fair play if they were to pursue post facto action, which means after they have got possession, to look into this, has improved dramatically. So in my view, I think there is a very good chance now, when there is a strong case like this, of after getting possession, if the customer was to take the effort to follow through his legal remedy, and we are all scared of how long the legal process may take, but things have changed on the ground, and especially in cases that are sort of known to be one-sided. And I think the force majeure clause, not only does it sound ludicrous when you read it out, but imagine in a court of law when this is talked about, it will be quite clear that it is not a balanced or a fair agreement, and that there's more leverage with the developer than with the customer. So I think it's a fair chance of getting a positive outcome, and I think this path is the right path for him to take.
Wow, gentlemen, that's music to the ear of the buyer and the consumers. Really, for the longest time, tables have been so stacked against the buyer and so in favor of the developer that it's nice to know the tide is changing, things are changing for the better as we go along. Vinay Singh, thank you very much. Samar, thanks very much for taking this question. We'll be back next week again with another smart advice, a large problem that buyers are facing, and some really smart advice like today on how do you get the best or the better of the developer. Frankly, take your possession because prices have gone up, and then fight for your rights, and the court and the justice will be in your favor, looking at the big awareness around what developers are doing, which is not fair, and the judicial activism that we just spoke about. Thanks very much for joining us.